Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, stay ready. You can call your first witness. We like to switch it up every once in a while.
Yeah, I was like,
have it go
this-
one
yeah, this
side,
is
then the
different.
other. It's kind of like 6 or 7, is that what this is? Yeah.
Good morning. Can you state your name, please, for the record?
Wendy James.
And Ms. James, are you a probation officer with the Board of Probation and Parole?
Yes, I am.
Were you requested to complete a precedence investigation report on Mr. McElhaney?
Yes.
Okay, is the rule requested? You turn your microphone on, I can hear you better, but
Yes,
you
sir.
have witnesses, are you asking for the rule?
Well, I'm not asking for the rule. However, I thought I would bring up my witnesses in case.
I don't have any opposition with witnesses
Just
staying
let
in
them
here.
say in the courtroom, the rule is more important in a evidentiary hearing at a trial than it would be at a sentencing hearing.
Yes,
All
sir.
right. Thank you for bringing it to our attention.
All right, Ms. Officer James, when you began your precedence investigation report, can you tell us what you do in regards to gathering information in order to put that into the investigation report?
I request an NCIC first to get a criminal history. I set up an interview with the defendant, and I try to also interview the victim to get information.
And did you do that in this case?
Yes, I did.
Okay. And it looks like as well, if in the precedence investigation report, you also went through Mr. McElhaney's prior probation history?
Yes.
Okay. Can we turn to, it looks like page 6 of your precedence investigation report? You stated at the bottom of that page, you start the prior record.
Yes.
Can you list to the court the prior criminal history convictions that Mr. McElhaney had that you were able to find?
Okay, well, the most recent was the violation of probation out of Murray County, and that was on these charges. They have violated him and reinstated after 90 days.
And was that because he was on probation when these charges were committed?
Yes.
And I'm sorry, you can go ahead.
And then, do you want me to do the disposition date or the offense date on these, or just the list of?
The disposition date will be fine.
Okay, so disposition date of 1/2 of 24 was when he was placed on probation for burglary and theft. He got a 3-year sentence. And then prior to that, 5/30 of 2023, he got a 1 year to serve for theft of property. And then I think the disposition dates on the following, I think 5 or the same date. It was evading arrest, casual exchange ×2, marijuana, and unlawful drug paraphernalia. And then prior to that, 5/30 of 2023, he got a 1 year to serve for evading arrest. 9/28 of 21, theft of property, 2 years suspended to probation. 1/9 of 2020 was a VOP. Another 1/9 of 2020, he got a casual exchange, prohibited weapons. And then 6/10 of 2019, casual exchange. 5/8 of 19, contempt of court. 5/27 of 2020, license suspended. 4/19, 2018, contempt of court. And theft of property, shoplifting, driving with license suspended. 3/19, 2015, DUI. 11/30, 2011, he violated his probation and was reinstated. 1/14, 2011, Schedule 6 drugs. 1/24, 2011, a DUI. 1/14, 2011, Schedule 6 drugs. He got 2 years probation. 11/1, 2011. Okay, that was a prior record created. It was a Schedule 6 drugs. 2 of those. And then 4/26, 2004 was casual exchange, 11/29 probation.
So in looking through his prior record, it appears, based on the information you provided, that he has had criminal convictions from the age of 20 up until today, where he is approximately 40. Does that
Yes.
sound correct?
Yes.
So for about 20 years, he's had convictions consistently through that time?
Yes.
Okay. And can you tell us, in regards to page 12, the prior probation history as well? Can you go over that with the court, please?
So I pulled this from all of the notes in the computer. So it looks like 1/14 of 2011, he got put on probation for 2 years for Schedule 6 drugs. While he was on probation, he got arrested for domestic, but that was retired. In 8/29 of 2011, he got a VOP on a new arrest for drugs. 11/1 of 2011, he got 2 years split confinement, but that was pending prior to the initial probation. 4/9/2012, determinate release probation. 4/2/2013, he got a partial revocation, had to serve 90 days and then be reinstated, and as a condition, complete the Hope Center. And he did enter the Hope Center on 5/15/2013. His sentence was allowed to expire because there was no extension put in to allow him to complete Hope Center, but he told me that he did complete Hope Center after his probation had expired. 5/30 of 2023, he got 1 year to serve for theft of property and then got a determinate release with a detainer. 1/2 of 2024, return split confinement, burglary, theft, and property. 3 years. Guess that was probation. 8/2 of 24, a new arrest for the current charges, and then 9/3 of 24, the VOP warrant for the new charges. In 12/5/2024, he was partially revoked and to serve 90 days and then reinstate, and then 12/16/2024, he was reinstated to that Maury County probation.
Okay. And I presume on this prior probation history, that is history that you would have had through state probation, is that correct?
That's where I
So
got the notes.
that doesn't include any misdemeanor probation or if there was community corrections?
No.
Okay. And did you have an opportunity to speak to a victim in this case?
I did.
And who was that victim?
Miss Mildred Thaxton.
Okay. Did she speak with you over the phone or were you in person?
We spoke over the phone.
Okay. And she provided you some information in regards to this case?
Yes.
Okay. And then ultimately, on the last page, there is information in regards to our needs and risk assessment. Can you tell us a little bit about what that is?
Well, it's an assessment that we do that lets us know the risk for the offender reoffending, and it lets us know the needs that they have that may help them in probation or their sentence to keep them from reoffending.
And what was Mr. McElhoney's score, risk assessment score?
He scored high risk.
Okay. Is that the highest that probation has categorized under their risk and needs assessment?
Yes.
Okay. Your Honor, I would ask to make this precedence investigation report an exhibit in the sentencing hearing.
No objection, Your Honor.
All right.
Does the court have a copy?
I have a copy that was marked, that was filed with the court. We'll just make that the exhibit.
Thank you, Your Honor. No further questions.
Talbot, you have a question?
Thank you, Ms. James. You said that you had talked to the victim, Miss Mildred Thaxton, by phone. Is that right?
Yes.
Okay. Did she tell you that the defendant actually entered her home?
No, she said he tried to get into her home.
Okay. So where it reads in the report on page 5 that the defendant made it inside her home, that's not in fact the case. Is that accurate?
No, you
I see
left
what-
off half of the
Okay,
sentence.
I see where I've messed up on that. Yeah, no, forgive me, yeah. You, in fact, pointed out that it was speculating about what would happen had he
Yes.
made it into her home,
Yes.
which he did not.
He did not.
Okay, she didn't say he made it into.
No.
Okay. So in that case, and you would agree that you found no indication that any property had been taken from the victims in this case?
No,
And that nobody was assaulted or hurt?
no.
And then regarding the defendant's criminal history, you found no signs of any convictions for a robbery,
No,
okay? No convictions for assaults or anything like that?
no.
He was just charged with a domestic assault that was retired at some
Yes.
point? He had evading charges, is that correct?
Yes,
Okay, and then he had several drug convictions?
Yes.
And then also some property crimes, is that fair to say?
yes.
Okay. And did you interview the defendant?
I did.
Okay, when did that occur?
That was October the 9th.
Okay. Was that an in-person interview with the defendant?
It was.
Okay. And did he express that he'd been using drugs and alcohol?
Yes, he did.
Okay. Did he tell you when that started?
He did. He said that the heavy use started after his mother had passed away.
Okay. And did he say when the death of his mother occurred?
He did.
Okay. When was that?
Hold on, let me find it. I don't remember. I think it was 2018. Yes. 2018.
And did he also report having an overdose in 2019 on heroin?
He did.
And did he admit to you that he has a drug problem?
Yes, he did.
Okay. And do you believe that he has a drug problem based
I
on the
do.
information you have?
Yes.
Okay. Did he express to you that he wanted to change his life to be a role model for his children?
Yes, he did.
Okay. You wrote on page 16 that your recommendations for the plan of supervision would include the victim's impact, as well as other recommendations based on the personal interview with the defendant. One of those is the completion of a long-term drug treatment program. Do you believe that that would benefit Mr. McElhaney?
If he is ready to change, I believe it would.
Okay. And did he express a willingness to change his behavior?
He did.
In the strong R risk assessment, you rated him, or he ended up being rated as high, is that correct?
Yes.
Okay. Now, it showed some results regarding his needs as someone who was assessed for risk. On the category where it said moderate need, there is a scale that says 62% moderate need in the area of friends/associates and residential. What does that mean?
It could mean the people he is associating with, and also it's where he lives. For some reason, if an individual owns a home and lives as the primary resident or head of household, it rates them lower in score. If they are living with family members, it rates them higher.
Okay. And why is that? Why is it higher if living with other people?
I'm not sure.
Okay. I have no further questions. Thank you.
General, you redirect?
I just wanted to follow back up on the questions in regards to the defendant's version when you interviewed him. I know that you were asked whether or not he said he was on drugs at the time, but what was his explanation for being on the property of these victims?
He said that he was on his four-wheeler and it had run out of gas, so he had stopped to look for gas and didn't find any, so he was walking home and he got hot and needed a drink of water, and so that's when he went on to Miss Thaxton's property to use her water hose.
Okay. And do you know where he was living at the time?
He was living with his uncle at 806 Pruitt in Dixon.
Okay. And do you know his uncle's name?
Not right off the top of my head, but it's in the report. Timmy?
Okay. And then let me go back to, as well, you were asked in regards to Mr. McElhaney's motivation to be involved in the lives of his children. Is that something he told you?
Yes.
Okay. And throughout this report that you created through your investigation, did he also tell you that it had been quite a while since he'd seen his children?
The youngest, I think he said he hadn't seen in a couple of years.
And then in regards to child support, were you able to determine if he owes child support on his children?
He did tell me he is around 90,000 in arrears.
Okay. So something that he's obviously, that would build up over a period of time,
Yes.
clearly. Okay. Thank you. I don't have any further questions.
I have no recross, Your Honor. Thank you.
Sure, go ahead. Ms. James, you read off a list of the defendant's convictions that you had researched and found convictions. Did you ever total how many convictions he had?
I did not.
Had there been, if I understood correctly, he'd been placed on probation and revoked on probation?
Yes.
How many times did that occur?
Not sure without looking
all
through.
right.
I think 2 or 3
If you-
times.
all right. That's all. Thank you. You may step down. State may call its next witness. Raise your right hand and be placed under oath.
Swear or affirm that
I do.
Will you state your name for the record, please?
Deputy Hargrove.
And Deputy, is your first name Cody?
It is.
Okay. You work for the Dixon County Sheriff's Office, is that correct?
Correct.
Were you working back on August the 1st of 2024?
I was.
Can you tell us how you originally became involved in this case? Were you dispatched out, or did you have a traffic interaction? Tell me how you became involved in the case involving Mr. McElhaney.
Yes, ma'am. At approximately 9 o'clock that night, I was dispatched to Furnace Hollow in reference to a suspicious person.
And when you got there, who did you speak to? Who did you see? Did you see a suspicious person?
Upon arriving at the address that was given per dispatch, I made contact with the homeowner, and he provided some video of a subject that was walking around on his property with a light. They had already priorly searched the property and said that he was no longer on there. While I was on scene, the homeowner advised that he contacted the subject, and when he did, the subject stated that he was there looking for a guy named John. When the homeowner told him that there's no John here, the subject stated okay and then turned and left the property.
And do you know who the victim was in that case?
Michael Zajac.
Okay. And was Mr. McElhaney later identified as being the person on his property?
Yes, ma'am. After I left the property, I patrolled the area and I made contact with Mr. McElhaney at the intersection of Eno and South Eno.
Did you speak to Mr. McElhaney at that point in time?
I did, due to the call and it being 9 o'clock at night and he's sitting in a church parking lot. I made contact with the subject. He identified himself, and whenever I asked him if he had been around in the property or whatnot, he said he's been mowing all day and he was just out walking around.
All right. What did you tell him at that point in time, or did you arrest him at that point in time?
No, ma'am. At that point in time, due to the fact that he was asked to leave the property, he did leave the property. I just conveyed the fact that he's formally trespassed from the Furnace Hollow property.
Okay. Did you later find out more information in regards to Mr. McElhaney's involvement at Mr. Zajac's property?
Yes, this was after a separate incident that I found out that there was more to do with that property.
And go ahead and tell us, I guess, either the second incident or what you found out later about that property, whichever is the appropriate order.
So to have the appropriate order, approximately 2.5 hours later, we got another dispatch for a suspicious person at 1325 Eno. Upon arriving on scene, I made contact with Miss Thaxton on her front porch, where she advised that she had seen somebody walking around on her property with a light. I searched the property, her backyard and barn and stuff, and could not make contact with the subject. Another deputy arrived. We searched the area, split off in different directions. The other deputy decided to go back to the address just to make sure. At that time, we made contact with Mr. McElhaney, and just due to the situation, we detained him just so we could figure out the situation. It was found out that he was in the backyard of Miss Thaxton using her water fountain. While we were back there trying to get his side of the story as to why he was on her property to begin with, he stated that he was thirsty, and at that time, Miss Thaxton's son, Kelly, walked around the back and was asking Mr. McElhaney, did he steal his gun out of his truck because he was on his property as well. Mr. Kelly stated that he also had seen somebody on his property with flashlight, which is why we split up into different directions in the first place. whenever I went around the front to talk to Mr. Kelly and Miss Thaxton, Miss Thaxton advised that she heard someone jiggling the front door, never heard anybody knock. And when she heard us making contact with the subject in the backyard, she opened the front door and she observed a firearm that looked familiar. Whenever Mr. Kelly arrived on scene, he went inside and he observed that it was his firearm that he stated he had locked in one of his vehicles on his property.
Okay, so Ms. Thaxton had found a gun on her porch after Mr. McElhaney had been jiggling the door. Is that-
Correct.
Okay.
And when I
And then-
first made contact with Ms. Thaxton, we met on the front porch, and I did not observe any firearm on the front porch.
Did she say that she had brought the gun inside?
She did.
Okay. Now, circling back to, you said later on you found out information in regards to Mr. Zajak's property. What did you find out at that point?
Yeah, so whenever we called a detective out there due to the situation, advised the detective that I had made contact with the McElhaney subject earlier in the day around Eno, South Eno. I advised him of what had occurred and gave him the address of the Furnace Hollow. He decided to go back to the Furnace Hollow address and speak with the victim there. And it was later found that there was video of Mr. McElhaney going into the garage of the Mr. Zajac, which is attached to his house.
Okay. And approximately what was the, if you know, what was, you said that originally after the incident with Mr. Zajac's home out on Furnace Hollow, you saw Mr. McElhaney on Eno Road. What was the distance between where you observed Mr. McElhaney on Eno Road and where you were dispatched out to later for Miss Thaxton and Mr. Thaxton?
It's going to be approximately 2 to 3 miles.
Okay, so they were both on Eno Road, is that correct?
Correct.
Okay. And you requested the warrants on Mr. McElhaney that evening, is that correct?
That is
In
correct.
regards to at least some of these charges?
Yes, that's correct. Whenever I gave the detective the description of clothing that was the subject was wearing for Furnace Hollow, whenever we made contact with Mr. McElhaney at Miss Thaxton's house, he was wearing the exact same description, and also that there was a dog involved as well that was following him around. So he matched the description on both incidents.
All right. And you were able to obviously determine that Mr. McElhaney was the person that you spoke to at the
Correct.
church, as well as the person on Ms. Thaxton's property? Is
Correct.
that correct? Okay. Thank you. I don't have any further questions. If you'll please answer any questions of the defense.
Yes, ma'am.
When you encountered Mr. McElhaney at Miss Thaxton's residence, he was drinking water from the water hose in the backyard?
So whenever I arrived, the other deputy had already contacted him and stated that he was using the water faucet and was already detained when I got there, but he was soaking wet from where his shirt and pants were both soaking wet, and that's when the deputy said that he was using the water faucet.
Okay. And this was in August 2024, is that right?
Correct.
Yeah, was it hot?
It was warm outside, but not enough to where it would sweat and have that much wetness on the clothing, because we wear body armor and I was not sweating that bad.
And was there any property belonging to any of the victims in this case in Mr. McElhaney's possession when you encountered him?
Whenever I encountered him, no. The only thing that we have that belonged to somebody else was the firearm that was found on the front porch at a later date after I'd already been on the front porch.
Okay, so you never saw that, you never located that firearm in Mr. McElhaney's possession?
No, I did not.
Okay. And then regarding the truck described by Mr. Kelly Thaxton, did you look at his truck?
No, due to the situation and there only being 2 detectives on scene, the other deputy went to the vehicle and then just to secure the scene until the detective got there, and the detective took over with the vehicle theft from there.
But Mr. Thaxton's claim was that this firearm was his and that it had been taken out of his vehicle. Is that right?
Correct.
Okay, but Mr. Thaxton didn't say that he saw Mr. McElhaney do that, did he?
No, he stated that he saw a subject with a light, which was the case with all the other incidents on his property, and that his vehicle was locked earlier in the day, and that he could vouch that it was locked earlier in the day.
And you weren't able to see that vehicle to determine whether it was, had any damage to it, which would indicate that it had been broken into while locked? You didn't
I
see
did not lay eyes on it due to the fact
Okay.
that I was staying on scene at 1325 Eno.
When you encountered Mr. McElhaney at Mr. Thaxton's residence, did he still have a dog with him?
No, not that I observed. But the clothing description matched to a T based off what I observed on the prior videos.
Okay. Thank you.
Yes, sir.
Redirect. Thank you. You may step down. Do you have any other witnesses, gentlemen?
You solemnly swear or affirm that the testimony in this case is
You.
Will you state your name for the record, please?
Michael Williams, Ajax.
And Mr. Zajac, do you live on Furnace Hollow Road?
I do.
Okay. And did you have an occasion to contact the police back on August the 1st of 2024?
I did.
And can you tell us what happened at your home and what you saw that evening?
Yes, on that evening, I had just returned from a trip from Chicago. I'd only been home for probably less than 2 hours. At that time, we're getting ready for bed, getting the kids ready for bed, and I noticed floodlights coming on outside. The floodlights are motion activated, so I thought it was suspicious. And as I walked around the house, I saw more floodlights going off, so I went out on the front porch, at which point I encountered Mr. McElhaney and asked him to leave. I asked him, he said he was there to see John. And I said, there's no John here and you need to go. And at that point, I realized I was sitting on a brightly lit front porch with him in the shadows. So I retreated back into my home and grabbed my pistol and made sure he had left the premises.
All right. Did you determine at a later point that Mr. McElhaney had gone into any of your buildings or home?
Yes, I did. Upon running into that, I did look at the video. I did see him walking around the property with a flashlight and a dog. On every single one of my, I have multiple video cameras on the property. Every single camera saw him. Got a very good look at him at the doorbell, peeking into my windows, where my daughter was sleeping on the couch. And also realized that he had entered into my attached garage and also my barn on the property.
Okay, so you had surveillance footage, is that correct?
Yes, he was also using his flashlight to look into the 2 campers on the property and trying the doors to get in those as well.
Okay. And did you provide that footage to the detective, I guess, in this case?
Yes, I did.
Okay. And did your video show that all of that, what you had testified to about peeking in the windows and going into your attached garage and the camper, did that all occur that same day?
Yes, just for clarification, he did not enter the camper, but he did enter the barn, and yes, that all occurred at roughly the same time period.
Okay. Thank you for clarifying. Was anything stolen from your property?
Nothing tangible, but my family's security was stolen that night.
Okay. Well, tell the court how this crime affected you and your family.
Yeah, as a result of this crime, my family has had trouble sleeping. They've had trouble, being secure in the home. Every night, one of us checks multiple times every single door to make sure it's locked. We've had to invest thousands of dollars into a security system and pay a monthly fee. And my family is in fear when I leave the house, which is weekly for work, that I travel for work. So it's had a very significant and profound impact on my family. Like I said, their sense of security has been stolen and no amount of money can give that back.
Okay. Are your children minor children?
Yes, at the time of the incident, I had a 7-year-old and a 12-year-old, and the 12-year-old was asleep on the couch.
Okay. Is there anything else you want to tell the court in regards to this incident?
First of all, I would like to thank the Dixon County Sheriff's Department for their promptness and professionalism throughout the course of the incident. And would also just like to state that, again, there's got to be, people have to be accountable for their actions. This action has a profound and deep impact on my family. And in this case, considering the history, we'd like to request the maximum penalty.
Okay. Thank you, Mr. Zajac. I appreciate it. If you'll just answer any questions of the defense.
Yes, ma'am.
Talbot?
You reviewed the video footage from your home security cameras,
Yes,
and you saw the defendant at your property?
yes.
Now, based on the time of that footage, was that prior to or after the interaction that you had with the defendant?
I believe it was prior to the interaction. Based on the footage, I had asked him, when I asked him to leave, it appeared that he retreated back towards some overgrowth by my barn, which I have since cut down. As a result of this incident, did significant property maintenance to make sure that there's no hiding places. It appeared that he was hidden, and as I walked out and I yelled, if you're still here, you better not be. And at that point, he appeared to retreat off the property.
Okay, so you've got your video footage that shows the defendant at your property
Yes,
at a certain time.
Yes.
And later that evening, is it fair to say, that's when you noticed somebody out there and you spoke with the defendant, told them
Yep.
to leave?
Yes.
Is that a fair timeline? Is that a fair timeline?
I'm not, you didn't say any times on there, but it
Sure.
sounds right. in
We'll say
the order of
sequence
events, yes.
Sure. When you interacted with the defendant, he had told you that he was looking for a John.
Yes.
What was the defendant's demeanor like at that time? How would you describe his behavior?
I would say he seemed sleepy, I guess for lack of a better word, and aloof.
Did he seem confused?
No, I wouldn't say it in those words.
You said sleepy. Was he unsteady on his feet, or did he have a certain expression? What made you think sleepy?
It was hard to tell just by the tone of his voice. He was kind of in the shadows when I encountered him.
Okay. All right. Thank you, sir.
Thank you.
Redirect? Thank you, Mr. Zajac. You may step down and have
Thank
a
you.
seat in the courtroom. State may call your next witness.
Harm the testimony.
Good morning. Will you state your name, please, for the record?
My name is Mildred Thaxton.
And Ms. Thaxton, you live on Eno Road, is that correct?
Yes, ma'am, I've lived there 65 years.
All right. That's a long time. Did you have a reason to contact the police back on August the 1st of 2024?
Yes, ma'am, I did.
Okay.
My son called me and told me to lock both of my doors, turn my porch lights on, because he saw a guy in his yard. But the time my son went in the house to get his gun to go out there and talk to the guy, he was already in the woods. And my son told me he's headed my way, so he came in the woods to come to my house.
So does your son live like on an adjoining property?
Yes.
From you? How far away would you say he is from you?
I would say probably 2 blocks, maybe.
Okay. All right. So a little bit away, but not too far.
No,
Okay. And so he reached out to you to make sure that you were safe.
right.
Was there anybody else in the home with you?
No, ma'am.
Okay. Did you do what he said? Make sure
I
you
did.
locked your doors and,
I did.
okay. Did at some point in time, did you encounter Mr. McElhaney?
The only first time that I encountered him was when he was on my front porch.
All right.
He had laid the gun down there on the chair, and he wasn't knocking like he would, want me to come to the door. He was pounding on my door,
All right.
and I was so scared. And then this was at 11 o'clock at night, and I heard my pump come on. And I thought, they're not feeding the horses out there this time of night.
Tell me what that means by the pump. Is it like
I have a well.
a well? Okay.
I have a well.
And does it make a certain type of noise or something when it
Yeah,
comes
it
on?
comes on, because it's on my back porch, the pump is.
I see.
And so it comes on when the water comes on. So I went to the bathroom and looked out the window, and he was taking his clothes off. He'd already taken his shirt off, and he had the hose, and he was spraying his body down. So I went back and I called my son again. I said, please tell the cops to come quickly because he's here. And so he sat down on a cooler that I had on the patio, and then that's when they came in and got him.
Okay. So if I understand the order of events, he came onto your porch first, is that
Yes,
correct?
the front porch.
Were you able to see him on your
I
porch?
could see him through the crack of my window.
Okay. And did he appear, or did you think he was trying to come into the house, I guess is the
I
question.
knew he was bound and determined to come in my house.
And tell me why, like what made you
Because the
feel
way
that?
he was knocking on it.
Okay.
Normally a person, if they come to your house, they would just knock, with their hand, but this was pounding.
Did he jiggle the doorknob?
Yes.
Okay. So in regards to the gun, were you able to identify the gun?
Yes, I did.
And how did you know who it belonged to?
I knew it was my son's because my husband gave it to him.
Okay. And when did you see the gun laying on your porch?
As soon as I heard the knock on the door, I could see out the crack of my window, and it was laying across the chair there by the door.
Okay. And that was during the time that Mr. McElhoney was up there?
Right.
Okay. And at some point in time, did you get the gun off of the front porch and bring
I
it
did.
inside?
I did.
When was that?
After he had left off the porch. I didn't know where he went, but my son came down there, and we took the gun in the house.
Okay. Can you tell the court how this experience has made you feel? How it's
Well,
affected you?
I have had many, many nights of sleepless nights, plus I had to go to the ER, and my heart doctor had to put me on some depression medicine because I couldn't sleep. And I've never had an experience like that. Like I say, I've lived there 65 years, and we have never had anything like this to happen.
Right.
And I was talking to my neighbor, the one that just you interviewed, and told him, please don't move out of the area because we don't never have anything like this going on in this area. Please don't move back to where he came from.
Sure.
Because they were really nice people.
Right. Is there anything else that you wish to tell the court in regards to this experience or just in general?
Well, just like I say, I've never been through anything like this, and it's been devastating to me. I try to stay busy to keep my mind off of it, but it's hard. And then, like I say, I'm not getting much sleep at night. This has been going on for quite some time now.
Okay. Thank you, Ms. Thaxton. I appreciate it. If you'll answer any questions of the defense, please.
Mr. Talbot, you have questions?
Ms. Thaxton, this happened in August 2024, right?
Mm-hmm.
So over a year ago?
Over a year ago.
Okay. Has your sleep improved at all?
It has some, taken the medicine that the doctor gave me, but I'm still having nightmares.
And you said that you went to the ER after this incident. How quickly did you go to the ER after the night?
I was trying to make my mind up if I really wanted to go or if I didn't want to go. I didn't call any of my family. I just got in my car and I drove myself over there, which I shouldn't have done because I was in such a state of mind, but I did.
Was that the next day or how soon after?
That was that morning at 1 o'clock.
So in the middle of the night, you went to the ER after this?
Right.
Okay. Were you diagnosed with any kind of new condition as a result of this?
They just said it was anxiety.
Okay. You stated that the defendant pounded on the door. Okay. Was this the same kind of knocking? Well, what did you take the pounding to indicate?
I think maybe he thought that if he pounded hard enough that the door would come open because I live in an older home. And I felt like that's what he thought he was going to do. And at that time, I went and got my gun. I'd hate to know that I had to hurt anybody. I'm not that kind of person. But if somebody's going to come in and try to kill me, I'm going to take revenge.
So the pounding on the door, you would agree that people knock on doors in order to get the attention of the occupant inside the house?
Yes.
So couldn't this have been knocking on the door to get the attention of you inside the house?
Well, I mean, it could have been, but when he started pounding on it, that's not a regular knock. That's determined they're going to try to get in.
Okay. But to be sure, the defendant never entered your home, did he?
No.
Okay. And he took none of your property, did he?
No, not that I know of.
Okay. All right. Thank you.
I'm sure there's some in the woods back there somewhere because as far as I know, there was about 11 homes affected that day.
Thank you.
Redirect. Thank you, Ms. Thaxton. You may have a seat. State may call your next witness.
Upon, as well as previously I'd filed a notice of impeachment, Your Honor, for the court's consideration.
At the time that the plea was entered, my understanding is he entered it as a range 3 offender, is that correct? So we're dealing with a
Yes.
Class C felony, range 3, 10 to 15 years.
I do believe we agreed to a cap of 10 years, Your Honor.
To a what?
A cap of 10 years. It's more for the fact, Your Honor, of the range of punishment to provide the court with information in regards to his criminal history.
Oh. State has rested their proofs. Talbot, you have proof you wish to offer.
Yes, sir. Thank you, Your Honor. I will call first Ms. Kim Hodgen, please.
solemnly swear or affirm to
Oh, yes.
All right. Ms. Hodgen, please state your name.
Kim Hodgen.
And how do you know the defendant?
I'm his aunt.
Okay. And are you familiar with his life?
Yes, sir, I am.
Okay. And have you always lived nearby each other or in the
Yes,
same
sir.
state?
Yes, sir.
Okay. And do you live in Dixon County?
Yes, I do.
Okay. So with Mr. McElhiney, do you believe that he has a drug problem?
Yes, I do.
All right. What makes you say that?
Every time Wesley has been in trouble, it's due to drugs. The past, I want to say in 2011, 2012, 2013, it's all drugs. it escalated into heroin. Each and every time he's ever been pulled over or he's been in custody, he's been on drugs.
And have you seen him under the influence of drugs?
Yes, I have.
Okay, can you describe an instance where you saw that?
Several times I have witnessed, and he has no clue what he's doing.
Okay. Most recently, what have you observed him being like when he's under the influence?
Like I said, he has no clue what he is doing.
Can you describe the circumstances of what you saw?
He's under heroin, sleepy. He don't even know his name. He don't even know what he's doing. The night that all this took place, I'm sure he didn't even know what he was doing.
Okay.
He is not a violent, he wouldn't even hurt a fly.
And you said you've seen him under the influence before.
Yes, I have.
When was the last time you saw that? What were the circumstances?
I would say that it was when he was on probation at my brother's, 2 or 3 days prior, before he got in trouble and got arrested. We reached out to his probation officer to come and give him a drug test to see if we could get Wesley some help, because I knew that this would be spiral back into what he done.
What did
that
you
night.
What did you see that made you think you've got to contact the probation officer?
Well, you can just tell. You can look at him and tell he was not responding well. He was just sleeping. His eyes was droopy. But he didn't talk right.
And you saw him like this in the residence of Mr. Tim
Yes.
McElhaney?
Yes.
Okay. And was this in around August 2024,
Yes.
July 2024?
Yes, and we
Okay.
reached out to his probation officer, and his probation officer said that he would be there that evening or soon, and he never did show up.
To your knowledge, what kind of work does Mr. McElhaney what kind of work has Mr. McElhaney done in the past that you're aware
He's a
of?
good electrician. He's a very excellent electrician.
When was the last time he did any electrician work, as far as you knew?
He
You know.
worked for a man in Centerville while he was living with my uncle. He was helping him do side jobs.
Okay, how recent was that?
What do you mean recently?
Yeah, how recently did he work for that man in Centerville?
I think he worked for him when he started, when he lived with my brother to own till, he didn't have jobs like every day, but it was pretty consistent.
Was that in
There for-
2024?
Yes,
Okay.
yes, sir.
All right. And have you seen, Mr. McElhaney, he has family, right?
Uh-huh.
Okay.
Mm-hmm.
And have you seen how drugs have affected his family?
Oh, yes.
Can you talk about that a little bit? I mean, you're his family, right? Mm-hmm. Okay. Can
Yeah.
you talk a little bit about that?
Yeah, it's upset us all. Wesley he hasn't been on every time we've had a family event or something. Wesley is very good. He brings joy to the whole family. Everybody loves him. His children adore him. They do not want their dad to go to prison.
Sure.
They want him to get help.
Okay.
Everybody knows that Wesley has a drug problem. He's not a thief. He's a good human being.
Have there been stretches of time where, as far as you could tell, Mr. McElhaney was not using drugs?
I'm sorry.
Have you, to your knowledge, have you seen stretches of
Oh,
time where
yes. Oh, yes.
Mr. McElhaney has
Yes,
not been
he's
using
held
drugs?
down jobs. He's worked for Pruitt Electric here in Dixon for a long period of time.
Can you tell the court about when that was, like a good time,
Oh,
when things were going well?
I don't know, it might have been, I can't even say what years that was, but it was a good, I would say between probably 2010 to 2012, 11, something like that. He worked with Purdue Electric, and then he worked for this guy in Centerville twice.
So is it fair to say that when Mr. McElhaney's not using drugs, he's employed and working?
Yes, he holds down a job. He's even done on my farm out at my house. He's wired all of our buildings, and different people in Tennessee City. Lived there all my life. He's done different work for a lot of people.
So when he's not using drugs, do you believe he's trustworthy?
Oh, yes, absolutely.
When he's not using drugs, does he take care of his family to the best of his ability?
Yes.
Okay. Is there anything else that comes to your mind as something significant that shows that drugs are his problem?
Oh, it's every time he's ever been in trouble, it's related to drugs. Every single time.
Do you see Mr. McElhaney frequently? Have you
yes.
seen him frequently over the years?
Oh, yes. Wesley has, he lived with me for several years there. Excellent, done good. He graduated from school. He lost his dad at a young age. He had a stepfather that was physically and mentally abusive. Wesley stayed with my parents and us for several years.
What years were those that he stayed with you?
Well, he'd be there on the summers. His
Okay.
mom would let him come stay
This is
summers.
this is when he's a minor? Mm-hmm. Okay.
Yeah. And she remarried. But his stepfather was very physically and mentally abusive. But he did graduate from school. He is a good electrician. He's got that up under his belt. Drugs he has fallen to drugs. He's didn't want help. He was in denial for a long time. But I honestly do believe that Wesley right now is ready for help. He needs, he's asked for help. I don't think prison would be the best solution for Wesley. I think if this court would give him another chance to at least get some help, I truly believe that Wesley would do good.
All right. Thank you, Ms. Hodgin.
Thank you.
I'll pass the witness.
Ma'am, if you'll have a seat, the state may ask you some questions.
Good morning, Ms. Hodgin.
Good morning.
So you are Mr. McElhaney's aunt, is that
Yes.
correct?
Yes, ma'am.
And are you related to, is it Tim? Was that?
Yeah, that's my brother,
And what's his last name?
McElhaney.
Okay, McElhaney as well. Okay. And so that's your brother.
Uh-huh.
Okay. And you live in Dixon County?
Mm-hmm.
Have you lived in Dixon County your whole life?
Yes.
Okay. So you said, obviously, you have then known Mr. McElhaney, I presume, his whole life?
Oh, yes.
Okay. And then I presume, since you've known him your whole life, that you're aware of his 20-plus years of criminal convictions?
Yes, I do. Yes.
All right. And I know you said on there that he is not a thief, but you do recognize that he has multiple convictions for stealing.
Yes, and I also said that it's due to drugs.
Right. But you agree that he has stolen from people?
Yes.
Okay.
to get his drugs.
All right. So the time period that he lived with you, you said it was just while he was a minor?
He stayed with us from like every summer, the whole summers.
While like in like high school age or?
Yeah, high school age, and then, he's been living with us for off and on for a while.
So basically, he would live with y'all for a while after he obviously became an adult and then go somewhere
Well,
else?
now he's lived in his own, he's lived there, he's rented for him and his family, houses, different places, But when divorced or something like that, he'd stay for just a small period of time.
Are there other places he would stay besides with you?
Where he lived on his own,
Okay. Did he ever stay with your brother?
just this last time, yeah.
Okay, so he was living with your brother when these crimes
Yeah.
occurred? Okay. And I don't know if it came up in the precedence report or not, because obviously you've been in the courtroom too, but Mr. McElhaney stated in his interview that he started using drugs back at the age of 16.
Yeah.
Does that surprise you?
No, because he had a dear, his mama was precious. I mean, she was very, very, very sweet, but I think it was pot back then. I think his mom smoked pot
Okay.
then.
And so he started that as well? Would he be using that when he was living with y'all over the
No,
summers?
we I've never witnessed him having any kind of drugs, anything, till after 18.
Okay. And so did you ever notice him using drugs while he was living with you? When he,
No.
like, off and on?
No,
Okay.
just this last time that he was living with my brother.
Now, you said you reached out because he was on probation when these crimes occurred, right? And that was out of Murray County, is that right?
I think so, I'm not.
Do you know why he was in Murray County at the time? Does he have any family that lives out there?
I don't know if I don't think so. No, I don't think he has any family.
Okay, so you don't really
I
know
don't
why
know.
he was out there? Okay. Was he on probation out of Murray County or out of Dixon County?
I think it was in Dixon, what, probation in Dixon.
Okay, I'm just asking, I don't know the
I'm not
answer to
too
that.
sure.
So do you recall the probation officer that you reached out to?
I didn't personally reach out to him. My brother and I were talking, and he reached out to, I heard him over the phone, reach out to him.
Okay. So y'all were concerned about his
Demeanor.
using
Yes.
again?
Yes.
All right. So during this time period that obviously you've known him his whole life, have y'all ever tried to get him to go to treatment?
Yes.
And where is that?
He first done the treatment at Hope Center for
Okay.
a little while, but then I tried to get him to go again, that Serenity or whatever it is in Memphis.
Okay. Is it Synergy?
Synergy, yeah.
Okay.
Yeah. But he didn't want to leave his family.
And when was that you tried to get him
I
treatment to
think it was
Synergy?
in 2017, 18.
Okay.
I-
And so, I mean, did you offer to help him or get him, transport him there or pay for what you needed to and that kind of stuff? And he just didn't want to do it?
At the time, he just thought he could handle it on his own. He thought he could do it.
Any other times that y'all encouraged him to go to treatment?
Just that time, and then he done good, and then he was living with my brother. And we were trying, after I seen that he was on drugs again, we reached out to the probation officer.
All right. Now, he didn't live with his children at the time of all these offenses,
No,
right?
no, but he stayed in contact with them.
Do you know where his children live?
Ava and Weston lives in Williamson County
Okay.
with their grandmother.
Is that your mom or?
No.
No. Okay.
No, it's not my mom. And then Autumn lives with her mom in Nashville.
All right. So does he have 3 children?
Yes, 4.
Okay. Is there one other child that we didn't
There's
mention there?
Addison is Megan's, his youngest one.
And where does she live?
I think she lives in Springfield or somewhere like that, yeah.
All right. And so he hasn't lived with his children for quite some time, is that correct?
I'm not too sure when's the last time he stayed with them, but he sees them periodically and they call.
Was he working before these crimes occurred?
Yes, he was working in Centerville with the electrician off and on, right there, yeah.
Are you surprised that, to hear today that he was behind on child support by $90,000?
I knew it was quite a bit, but
So, I mean, but he was working at the time, but not paying child support, it seems?
I don't know what if they was taking anything out or if it was court order for him for them to take it out of his checks or not. I knew that it was a while back, but I don't know.
Okay, well, thank you very much, appreciate it.
Redirect?
No, sir.
Thank you, ma'am. You may step down and have a seat.
Your Honor, for the next witness I wish to call, I'd like to call Mr. Scott Barnhill. All right. Mr. Barnhill, would you please state your name?
Yes, my name is Robert Scott Barnhill.
All right. And Mr. Barnhill, where do you work?
I work as a case manager for the 23rd Judicial District Drug Court Program.
All right. Did the drug court program receive an application from the defendant?
Yes, we did.
Okay. And was the defendant provisionally accepted to the program?
Yes, he was.
Okay. Can you state some reasons why the defendant was accepted provisionally to the program?
Well, we do a lot of assessments, probably, I don't know, 100, 200 years. We see a lot of participants or wanted to be participants in the jails and talk to them, and I've had them all from looking at me like they're just ready to go back to their cell, go to bed, from some trying to just probably get out of jail, and then some more intensive through talking with them, through emotions, through I'm tired of this life, and can visually see that they're ready for something different.
That last situation you described, was that your impression of Mr. McElhaney?
It was.
Okay. And to determine whether an applicant's accepted, how does that process work with the recovery court?
We have an assessment form that we use, that we do first with each applicant. And then we extensively speak with him after that over what do you want out of drug court. Just try to dig around and just see what kind of individuals. It's our one time to really probe and to understand and to feel where they are, and are they broken? Are they ready? You know.
The reasons given by Mr. McElhaney, do you recall any of those?
Yeah. I just know that after we finished the initial paper assessment, that we got to talking about, are you ready to really change? Are you at that time, or have you had enough? And he broke down crying on me, and I could tell that he's been down the road through drug addiction, and he just wants a way out. And so yeah, basically.
Did he express to you his goal in the recovery court process, should he be accepted?
He didn't go into much intention. He just said that he wants to, be sober. He wants to complete it. He wants a life like I'm a recovering addict, like me, like Doug, like the 300 and some odd graduates that we have. That we have a 82% success rate, that they not only stay out of the court systems, but stay sober. It's a very disciplined program. And
Is that 82% success rate, that's if someone does complete the program?
yes,
You're saying that 82% do not reoffend?
they do not, we just done a survey back with the state 3 years, for the past 3 years, and that's our percentage rate that we have come up with.
So if someone makes it through the program, they have around 4 out of 5 chance of not reoffending.
Exactly.
Within what time period?
I mean, I don't even know if there is a time period. You know, so as much as I've kept up with for the last 9 years, 9 years,
Yes, sir.
to my opinion.
Now, if someone doesn't complete recovery court, what happens?
They get terminated. I mean, they'll be either terminated and they'll go do their sentence.
So in recovery court, what services are provided to the applicant, should they be accepted? How would it start if Mr. McElhaney was?
If he was accepted in the
Accepted.
drug court, we would come to the jail, pick him up, the Dixon County Jail, and then we would either send him to a 28-day treatment program or a 1-year-long treatment program. As soon as he completes it, we will go pick him up. We will transport him there, we will transport him back, and then he comes back to drug court and starts his drug court venture, which will basically, all of our men work at the same plant. He'll get a job there, and he'll go to work. He'll be on house arrest for the first 6 months. He'll go to work. He'll come to our shop or office. He'll take a drug screen. He'll go into a group or meeting, whichever there is that day, and then return home with the guys at our sober living house and call his sponsor and work the steps, do his chores, and then can rest and get ready for the next day. Very disciplined program.
And if Mr. McElhaney were to break any of those rules, what could happen to him?
Well, as a team, we have a full team that we discuss sanctions regarding what the rule breaking is, basically. And it could, it could be as low as write-offs up to being put on hold. There has been jail time imposed on the weekends. There's a multitude of, it's all depending on what he kind of does, basically, to get a sanction.
And if there is a sanction, is there a court hearing on that where he has a lawyer representing him and he gets to argue about what happens to him?
Nope. Judge Lockett Mash and the team will get together and whatever he does or whatever we deem necessary to be the punishment for it, he will accept that as is.
And that can include revocation of his drug court and being sent to prison.
Right.
Is that right?
Exactly.
To serve the sentence that is ordered by this court.
Yep, and he won't know it until the guard comes behind him and handcuffs him and takes him away.
For people who enter the program, what is the chance generally of them succeeding?
I'd say a 75% chance.
Okay. And then after that, as you testified already, there's a good chance of them not reoffending.
Oh, exactly. Yeah, 82%. We just done a recent survey. Yeah.
So do you believe that recovery court works?
Oh, 100%.
Okay.
It worked for me.
Now, there was some testimony earlier about Mr. McElhaney going through Hope Center. Can you distinguish, this was Hope Center several years ago, I think. Can you distinguish that from what recovery court does? What's the difference?
Okay, well, the Hope Center is more a spiritual program. It also does CR. They have meetings and celebrate recovery and different things, but it works on a spiritual thesis, basically, that, and I believe, that through Christ, anything can happen. I have no doubt. He strengthens us all. But also know that discipline, because of our own self-will, that we have to be disciplined in that. We, as addicts, recovering addicts, we have to do certain things. It's like an antidote each day to be able to stay sober. I think you need the spiritual foundation, and I think you must have the discipline foundation. I think that the combination is why drug court works so well.
Thank you, Mr. Barnhill.
Yes.
Hi, Mr. Barnhill. I just have a couple questions for you.
Yes, ma'am.
So you're a case manager at the drug court. Tell me what that means.
Basically, I drug test all the male participants. I do groups with them. It just means that we're in constant, me and Doug are in constant, always around them, always working with, talking with them in our office, counseling, working them through things, issues. It means a lot of different things, but.
Do you live at the drug court housing as well with them?
No, ma'am.
Okay. Is there someone that supervises them that lives there with them?
Yes, ma'am. Each house has a house manager that supervises them.
And is that somebody that works with the program, or is that another participant?
That is usually another participant. We do have sometimes other ones that have went through Synergy and just, want to come into our houses that are very structured, but most of the time it's a participant that is in the upper phase that hold a lot of trust with us.
All right. So in looking at the provisional acceptance that was provided, it stated that you assessed Mr. McElhaney and you recommended CAP. Is that correct?
Yes, ma'am.
So CAP is only a 28-day treatment program, isn't it?
Yes, ma'am.
Now, why would you recommend that versus Synergy if Mr. McElhaney has an over 20-plus year usage history according to his own accord?
Well, I know I have met Mr. McElhaney before at the Hope Center. I used to counsel there and stuff. And I know what he's like to be sober. I know he's had that in him. Sometimes it just has to be brought back out or get into the routine. A lot of times people that we send to Synergy are have no treatment before or extremely high risk. And most of our participants are high risk. But I just deemed that 28 days would be appropriate for him.
And do you feel like, you are obviously able to hear it today too, that the probation has assessed him as high risk?
Yes, ma'am.
Does that change your opinion on what he may be, if he was allowed to go to drug court, what he may need?
No, it's possible.
Okay.
It is possible, yeah. We always discuss as a team, and a lot of our high-risk people that we get in, they can go through a 28-day program, and we can get them back, and they can do very well too, but it's possible that he may need a year
And then,
at Synergy or something.
and obviously, y'all know I'm a big advocate of the drug court for many people, but there are people that violate drug court. Wouldn't you agree?
Yes, ma'am.
Okay, obviously, this court, and I have seen them multitude of times coming in and having to drag y'all in to testify about a violation for that. Is that correct?
Yes, ma'am.
Okay. And it's not just as simple most of the time as that they just go and do their sentence, though, right? If they violate drug court?
It depends on what kind of violation that they have. You talking about like a termination or something?
If they're terminated.
Yeah, they go do their sentence.
Well, they're entitled to have a VOP hearing, aren't they?
I believe, I'm not for sure.
Okay. Most participants of drug court are placed on probation, is that correct?
I believe so. I know I don't know if it's different judges have different types of way that it is written up. So I'm not for sure if it's just a violation or if they've been furloughed. I'm not for sure.
Okay, but it's possible that in order to send a person to serve the rest of their sentence, they get to have yet another hearing in front of a judge, and not just Judge Lockhart Mash in the drug court.
I'm not for sure.
I'm going to object and just say it calls for a legal conclusion.
Sustained.
So tell us how drug screens work at drug court. How often do they get tested?
We have a color line that we have. It's red, white, and blue. We put different participants on red, white, and blue, depending on how they come in. I call a color every day. If I call red, it's your color. You come to the shop and you take your drug screens. They average, I'd say, about 2 to 3 drug screens a week. They are supervised, about as supervised as you could get as a drug screen. I don't think there's no way you could ever pull nothing over us.
All right.
So that's how that works, yeah.
And you'd agree as well that there's a lot of times that people in jail will express interest in drug court, but realize that it's because it's their only alternative to prison.
True, yeah. And we've had a lot of graduates that has clearly said that. They just wanted to get out of jail. And then guess what? They got into our drug court program. Things started changing. They got a relationship with God. They got a relationship with their family. They started paying taxes. They started paying their child support. They started paying their fines. Things just started happening for them. And they started changing. And they realized it was something they didn't want to let go of anymore.
And I think on y'all's provisional acceptance, it states as well that Mr. McElhoney has a hold out of Fairview. Are
Yes.
you aware of what that is?
I cannot remember if I wrote that. I just know he had a hold. The reason I know it because I know the Fairview's hard to deal with.
Okay.
Get him transported, and that's the only thing I can remember.
So even after today is done, if he was to be allowed to go to drug court, he'd still have to go to Fairview and deal with whatever they have on him.
Exactly. Yes.
Okay. And then, is he also required to serve a 180-day sentence in Robertson County for failing to pay child support?
Yes, ma'am.
Okay. So that's also something that he's going to need to go and deal with
Yes.
prior to ever getting to go to drug court, if that's an option.
Exactly.
Okay. Thank you, Mr. Burnhill. I don't have any other further questions.
All right. Thank you.
Anything further for this witness?
No, sir.
Thank you, sir. You may step down. We'll take a 15-minute recess.
Do you solemnly swear or affirm the
Yes, I do.
All right, Mr. McElhenney, would you please state your name?
John Wesley McElhenney.
Okay. And in this case, you've been convicted of aggravated burglary, vehicle burglary, and attempted aggravated burglary. Is that right?
Yes, sir.
Okay. And you're asking the court to decide your sentence and allow you to go to recovery court here in this judicial district. Is that right?
That's correct.
Okay. And I would like to hand you a document. Do you recognize this?
Yes, I do.
All right. What is it?
It's a acceptance letter to drug court.
Okay. Is that a fair and accurate representation of the copy of the letter you received showing that you were accepted provisionally?
It's exactly like it. Yep.
All right. Your Honor, I move to make that an exhibit to his testimony.
All right, mark it as exhibit.
All right. So, Mr. McElhenney, do you have a drug problem?
Yes, I do.
When did you first start using drugs?
Probably 14.
Okay. What drugs were those?
Marijuana.
Okay. And what led to that?
I don't know. I lost my dad when I was young, and my mom remarried, and man she married, he was not a good person, and he was abusive. So my mother let me kind of stay away from the house, and I got tangled up in the wrong bunch,
How was he abusive to you?
mentally and physically.
Okay. Like physically, he'd strike you?
Yes, sir.
Okay. And your father had passed away before that?
Yes.
Yeah. How old were you when your father died?
Well,
How did your father die?
he was killed in a car accident.
Okay. And did you have any brothers or sisters?
Yes, I did.
Okay. Did you have a brother?
Yeah, I've got a couple of brothers and a sister. But when my dad died, I had a stepbrother. His name was Casey, and we grew up together. And 4 years after my dad passed, he was killed in a dirt bike accident.
Okay. Were you close to Casey?
Yes, very close.
And do you believe that drugs played a role in your emotional life?
Yes, I do.
Can you talk about that? Why did you use drugs?
Well, like I said, I buried my dad, I buried my brother. I was 21, I buried my firstborn son. 4 years after that, when I was 30, I lost my best friend, my granddaddy, in a tractor accident in the front yard. 4 years after that, I buried my mother tragically. And I don't know.
You said your mother died in 2019, is that correct?
2018.
2018? Okay. What led to her death?
Well, she was diagnosed with a lymphoma disease years prior to this, and she had to do chemo and radiation, which is a form of breast cancer, and she beat it. And she developed MS, muscular sclerosis, because of the chemo and whatnot. She could walk around the house, she could do things. She could walk around Walmart without her getting these dizzy spells. So she was doing a sleep study at Franklin's Women Medical Center in Williamson County. And it was an outpatient deal from 3 to 6 o'clock. She had to sleep, and they would study her sleep patterns. Her insurance paid for her a hotel to stay nearby, so she didn't have to drive back and forth up there for 5 days. And the last night, I guess she got up during the night in the hotel room and had one of her dizzy spells, and she fell and she hit the back of a chair and crushed her esophagus and suffocated her there on the floor.
Were you close to your mother?
Very close.
Okay. And you said you started using, was it marijuana when you were young?
Yes.
Okay. Did you move on to using other kinds of drugs?
Yes.
And when did you start using something else, and what was it?
I don't know, after I graduated high school, I started experimenting with cocaine and pills and this wasn't enough. So it moved on to heroin, and I got clean there for a little while until my mother passed, and I knew if I went back to heroin that it'd probably be the death of me, and I started with meth, experimenting with meth, and
Did you overdose on heroin?
yes, I did.
When was that?
About 4 months after my mother died. It was probably January 2019.
Were you hospitalized for that?
I woke up in an ambulance on the way to the hospital.
Have you had periods where you used drugs and periods where you did not use drugs?
Yeah.
Okay. Can you talk about a time, some period of time when you were clean?
Well, I got, let's see, I got married 2009 to a lady from Williamson County, and we had 2 children, and I was sober the whole time. I was married to her for 5 years.
Okay. Now, you are aware of the criminal history that's been presented to this court, right?
Yes, I am.
And you agree that it's extensive, right?
Yes, I do.
Okay. Now, in that, are there charges, convictions that you got that had to do with drugs, your drug use?
Yeah, I'd say just about all of them, probably.
Okay. Can you talk about a theft that you believe was connected to your drug use?
In this case?
Not in this case, but in the past, where you've had criminal convictions.
I got 2 prior theft charges, and one time I was cutting a tree for this old man, and as I was cleaning it up, I noticed next door that a man had this huge pile of copper, and well, I come back a couple of nights later and some copper. And then my other charge is I traded some heroin for a vehicle, and I had a failure to appear, and the police come to my house and they run all the vehicles in the driveway, and that vehicle that I traded happened to be stolen. So they charged me with theft of property.
Okay. And you were convicted in both of those situations, right?
Yes, that's correct.
Okay. And then I want to ask, have you had custody of your kids in the past?
Yeah, all of them. In the beginning.
Okay. And did you lose custody of your children?
Yes.
Okay. Why?
Well, my 2 middle children, Ava and Weston, when I left my wife, I left her and the kids. And my oldest daughter, she's 18 now. But my youngest daughter, I haven't seen her in a couple of years. Her name's Addison. She's 9. The first 2 years of her life, she lived with me and her mother. And one day, her grandmother showed up at the house with an officer and took my kid and gave us a court date 3 days later. And they done a hair follicle test and took my little girl.
Okay. So, right now, do you talk to your kids?
Yes, I talk to them every day.
And they contact you in the jail?
Yeah, I have it. It's called a chirp. We can text message back and
Okay.
forth, and I talk to all of them.
I want to ask you about these charges, this case that we have in court. Oh, well, let me go back, actually. Excuse me. All right. Mr. McElhaney, you graduated from high school?
Yes, I did.
Okay, and you're trained as an electrician?
Yes, sir.
Okay, when was the last time you did any work as an electrician?
A couple of weeks before I got arrested.
And during those times when you've been clean, have you been working?
Yes, sir.
Okay. Regarding the child support that was brought up, have you tried to pay child support?
Yeah, I do. I try. My ex-wife, Ava and Weston, Ava's 14, Weston's 11. I'm supposed to pay $681 a month for the 2, and then Addison is $535 a month. So it's over $1,000 a month I'm required to pay for 2, 3.
And has drug use interfered with your ability to keep a job?
Yes, sir.
Have you been fired from jobs because of drug use?
Yeah, one time.
One time?
Yeah,
How recent was that?
a long time ago. I was in 2008, probably.
So this case, did you tell Ms. James that you were under the influence of methamphetamine at the time that you were accused of these offenses?
I did.
Okay. And on the property of Mr. Michael Zajac, why were you walking around his property?
Well, I ran out of gas, and I was trying to get home, and it was getting late, and I walked up to this house, I knocked on the door, nobody answered. I walked out. On my way out, I turned around and walked back to the garage, and the door was unlocked. I walked inside, looking for gas, no gas. I left. There was a building out at the end of the road. Went in there, just looking for some gas, man. I wasn't trying to.
What kind of vehicle were you driving?
On a four-wheeler.
Okay. And then regarding Ms. Thaxton's property, do you agree that deputies located you behind her house getting water?
Yeah, after Mr. Zajac come out and I left, I was sitting down at the community center. Police pulled up, questioned me, and I said, "Oh, I'm walking home." So on my way home, I've seen them coming. So I got off the road because I didn't want to have any more contact with them. And that's when I was walking through Mr. Thaxton's yard, and he come out and saw me. And it was hot. I got me a drink of water at Mrs. Thaxton's, and that's when they got me.
Okay. And did you take any property from anyone?
No, I did not.
Okay. Do you remember your state of mind then? You said you were under the influence of methamphetamine.
Yeah.
Did you know where you were?
Yeah. I didn't really know. I didn't know whose house I was at, but I knew which direction I was headed.
Okay. Okay. Now, since you've been in jail, let me ask you this. You were arrested in August 2024, and you've remained in jail ever since then?
Yes, sir. So almost 16 months.
So how many months is that?
This is the 16th month.
Okay. May I please hand the... Mr. McElhinney, do you recognize these certificates?
Yes, I do.
Okay. Tell me about these documents.
Well, they've got these iPads in the jail that they bring around about every 10 days, 3 days. And they have different programs on these tablets that you can take. And each section of these programs has a quiz to take. And these, I don't know, I think there's like 9 or 10 here that I have completed.
So are these your certificates that you've earned?
Yes.
Okay.
Yes.
Are these fair and accurate copies of the certificates that you've earned through completing these classes at the jail?
Yes, it is. Yes, sir.
Your Honor, I move to make that an exhibit to his testimony.
All right, mark it as the next exhibit.
And what sorts of things have you learned through the course of completing those classes?
Well, they've got different programs on there. They've got an electrician, HVAC, plumbing, building maintenance. They've got the CDL pre-exam on there.
Are those all items that you've completed?
Yes.
Okay. Is there anything about behavior, personal conduct?
Yes, there is.
Okay, what have you learned about personal conduct?
They've got I don't know, there's a wellness recovery program in there that just kind of teach you how to interact with people. And I've never really been a good people person.
Have you been clean and off of drugs ever since you got in the jail?
Yes, sir.
Okay.
Yeah.
All right. And are you ready to commit to the process of recovery court?
Man, it's been a long road and I'm tired. I can't do this anymore.
And do you feel like you understand the process involved in recovery court and the sanctions that could be used on you if you did not comply with what you're supposed to do in that program?
Yes, I do.
If you're allowed to go to recovery court, what is your goal for yourself?
Change my life. You know, I don't want my kids to be a part of my life. I just want to be a part of theirs and just do the right thing. Just work, do the right thing, and just be a part of my kids' life.
Are your kids watching you?
Yeah.
Do you think about what your kids think of you?
Yes, I do.
What do you think about that?
Well, my two oldest, 18 and 14, they know what I've been doing in my life, and you know, I'm just fortunate that they haven't turned their back on me, and I don't want that to happen.
Thank you. I'll pass the witness for now, Your Honor.
General Wojciechowski?
Hi, Mr. McElhaney.
Hello.
I have a few questions for you today.
Yes, ma'am.
So you testified on the stand that you had been riding a four-wheeler that day. Is that correct, of this incident? Where was the four-wheeler?
I had it hid off the road. I pushed it off in the field.
Okay. Was it your four-wheeler?
No,
So you had stolen that?
it was a family member's folder.
Had they given you permission to use it?
No, they didn't.
Okay. And when the officer came in contact with you, you told the officer you'd been mowing all day.
Told him that I cut grass here, that I didn't tell him I'd been mowing all day.
Okay. And when you went over to the home of Mr. Zajac, you told him you were looking for a friend that lived there.
Yeah, he scared me.
So you weren't really looking for a friend.
No, I was looking for gas.
Okay. And you agree that you were looking in the camper windows and that you were looking in, that you went inside of his garage and into his barn and different places of his property?
Yes. Your Honor, I'll object to that because Mr. McElhaney pled no contest to the allegations for which he is convicted.
Well, Judge, he's testifying about that day, so I feel like it's fair game to be able to ask questions about that day. He's been found guilty.
Well, a no contest plea means he doesn't admit anything. You can cross-examine him about what he has said, and if there's anything that relates directly to the offenses for which he has been convicted or the sentence that should be imposed, I think that's fair game. Your question, it has to do with what?
Judge, it has to do with the offense that he was convicted of, the aggravated burglary, where he went into the barn of Mr. Zajac's. And so I was asking about when he was on that property, what he said to Mr. Zajac, and then also what he was doing on that property.
Overrule the objection simply because the defendant, having testified on his own behalf as a witness, his credibility is subject to cross-examination and impeachment as any other person.
All right, so you could answer that questions in regards to, that I asked in regards to going into the garage. Did you go into his garage?
Yes, I did.
Did you go into his barn?
Yes, I did.
Did you look into his camper?
It's established that he's convicted of aggravated burglary. I thought her line of questioning was going to be about the interaction that he had with the homeowner. So I would renew my objection.
Overrule the objection on the same basis. This is a sentencing hearing, and therefore evidence of other crimes that have been introduced on the basis of his prior criminal history. In addition to that, he has testified about what happened, and I think the state is entitled to cross-examine him regarding his actions on that day and whether those actions are consistent with his version of the events.
Yes, sir.
You can answer that then.
Okay. Sorry, what's the question?
Did you look into the camper?
Yes, through the window.
All right. And were you out there with a flashlight that evening?
Yes, I was.
Okay. You didn't knock on the door of Mr. Zajac, right?
Yes, I did.
Did you ask him for help with gas?
No, nobody answered the door.
Okay. And so you decided, obviously, and you've pled guilty to it, to go ahead and start going into the homes, and it's not home, but I guess the attached part of his home in the garage, to look for things yourself, right?
That's correct.
Okay. Now, after you left the property, where did you go?
I went to the end of the road and I sat down at the community center, and that's when the officer pulled up.
All right. And he told you were trespassed, right?
Mhm.
And where'd you go after that?
I decided I was walking on. So on my way home, I saw police coming down the road, and that's when I got off the road, and that's when Mr. Kelly Thaxton, that's when he come out with a flashlight and asked me what I was doing. I told him I was walking home, and just kept walking, and I was hot. I saw the frost freeze standing hose bib up the end of the driveway, and I walked up, got me a drink of water, and did take my shirt off and squirt myself with water because I was hot, and that's when the police pulled up.
And you've pled guilty to attempted burglary too, and regarding to Miss Thaxton's home, is that correct?
Yes.
Okay. So you agree you did go up to her porch, try to wiggle her knob and pound on the door?
I don't think that I touched her house, but I did go up on the porch, yes.
All right. And let me ask you this. So if the officer was coming back by again and you hadn't been found in any trouble at that point, why didn't you just stay on the road instead of hiding from him and just ask for a ride home?
I was under the influence, and I don't know. I was under the influence, and I just I didn't want to have any more contact with him.
Now let's go back to the time period you said you were sober for about 5 years. That was when you were married, you said.
That's correct.
Tell me what years were those?
I want to say 2010, 2015.
So approximately that time, you were married the whole time and you were not using.
I mean, I wouldn't say I stayed clean for the whole 5 years, but I was doing pretty good.
Well, I mean, I think that's what your testimony was, that you were sober for 5 years while you were married. Is that not accurate?
Yeah, except for smoking pot. Yeah.
So you were still smoking pot?
Yes.
Okay. Do you feel like smoking pot is an exception to the rest of the drugs?
No, I don't.
Okay. So
I used to, but it's not.
Okay. And then around 2014 is when you got a DUI. Does that sound right?
That's correct.
So you were obviously under the influence of something at that point in time.
That's correct.
Okay. In January of 2024, you were convicted in Murray County of burglary of other than a habitation. Is that correct?
Yes, ma'am.
Okay. Why were you in Murray County?
I have some friends that live in Murray County, and I was just down there one night with some friends.
All right. And so you were convicted
Yes.
and you were placed on probation. Is that correct?
Yes.
Where was your probation officer?
I was on probation in Murray County, but it was transferred up here.
Okay. So did you have a Dixon County probation officer?
Yes, ma'am.
All right. Who was that?
Sir Joe, can't remember his last name.
It's all right. Did you ask your probation officer for help or treatment?
No.
And why not?
I don't know. I just got out of jail, and I knew, I thought I had it, and I thought I was okay.
So you didn't want treatment at the time. Is that correct?
No.
Okay. And you also testified earlier that you lost custody of at least one child or maybe all of the children due to your drug usage. Is that correct?
Yes.
Did you seek treatment when they took your children?
I know I did not.
Now, I've gone through and counted to your prior criminal history. Does it sound right that you have 9 felony convictions?
I thought it was 7, but I've never seen.
Okay. Did you look at the notice of enhancement that I filed?
Yes.
Okay. And so you think it's at least 7, but it could be 9?
Yes, ma'am.
All right. And including one of them when you ran from the police in 2022 in Hickman County? Do you recall that one?
Yes, ma'am.
Okay. I don't have any further questions, Your Honor. Thank you.
Albert?
You have undergone treatment in the past, right?
Yes, I did.
For drugs?
Yes.
Was that at Hope Center?
Yes.
Did you complete that program?
Yes, I did.
Okay. And as far as not seeking treatment other times, do you feel that people around you played a role in influencing you?
To not seek treatment?
Sure.
No, I don't guess, no. Maybe some friends. You know, I mean, they didn't say don't go to treatment, but
Do you feel that you've been influenced by people around you?
yeah,
Okay, to do drugs?
in my past, yeah. I wouldn't blame it on nobody but myself.
It's your responsibility is what you're saying?
Yes.
Okay. Do you think that a change of your surroundings and who you can associate with would help you?
Absolutely.
Okay.
Yeah.
Thank you, Your Honor.
I have a question. Mr. McElhaney, I've heard you testify about going up on, or what happened at Ms. Thaxton's house. How did the gun get on the front porch of her house?
I'm not sure about the gun.
Your Honor, he's not pled, if I may, he's not pled to possessing that firearm, that charge was dismissed in settlement.
Well, I'm sorry. Exactly. And the only thing taken out of the vehicle as testified was the weapon. So overrule your objection. So the question is, when you've been found guilty of burglary of an automobile, you pled no contest to that. The testimony here has been that the only thing taken out of that vehicle was the weapon that ended up on the front porch of Ms. Thaxton's house. So I'm asking you if you can enlighten me on how that occurred.
Your Honor, I pled guilty to the car burglary because it was part of the plea. And I asked why I was being charged with that if the gun was being dismissed, because I don't have any idea how the gun got
So
there.
you, even though you pled no contest to the charge of burglary of an automobile, you have no way to explain what was taken out of the automobile and that sort of thing?
No, sir.
All right, thank you. You can step down.
Yeah.
Mr. Talbot, you may call your next witness.
Thank you, Your Honor. I have no further witnesses.
Do you have any rebuttal proof? I'll hear you in argument.
Your Honor, just to recap what, and you may have it already in front of you, what Mr. McElhoney pled to in the agreement when he pled open on these charges is he pled to, on 2024 CR 134, he pled to count 1, aggravated burglary, which is...
Your Honor, I have to interrupt. I'm objecting. He didn't plead open. We have an agreement about the cap on sentencing. It's 10 years in the aggregate.
Gap of 10 years aggregate sentence be concurrent with my only other considerations.
That's correct,
I
Judge.
have
That's
the
what I was...
sentence. I have it in front of me.
Okay,
I want
thank you,
to
Judge.
repeat it.
That's what I was just trying to say. I was going to say the cap of 10 years before Mr. Talbot jumped up, so that's what we're looking at, Judge, as well as the fact that he pled to the burglary of a vehicle and the attempted aggravated burglary and agreed that he would be a persistent offender. Judge, I think what the court needs to face is the fact that he has an extremely long criminal history. He has been involved in committing crimes since at least the age of 20, according to the precedence report, all the way up until these latest crimes at the age of 40. The state did file notice of enhancement factors in which the state intends to rely upon under 4035-114, and that was that the defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range. Obviously, Judge, based on the fact that he has numerous felony convictions, my count was 9. Mr. McElhoney said it was 7. I would just ask the court to look at the notice of enhancement that the state filed in regards to looking at the prior criminal convictions. The other enhancement factors that the state placed on their, Judge, was that the victim of the offense was particularly vulnerable because of age or physical or mental disability. You heard today that Ms. Thaxton testified on there, and obviously Ms. Thaxton appears to be extremely sound mind and very capable. However, she is of older age and was alone in that home that night when Mr. McElhoney tried to break in. So I would ask the court give some weight to that. Number 13, at the time the felony was committed, one of the following classifications was applicable to the defendant, and he was released on probation. Obviously, there's no argument there. He was on state probation for a burglary other than a habitation in which he'd received a 3-year sentence out of Murray County. He was on probation for, it looks like, approximately 7 months before these offenses were committed here in Dixon County. And then the last one, Judge, was number 29. The offense involved the theft of a firearm from a motor vehicle while while the theft itself was dismissed, Judge, he was in fact was found guilty of burglary of a motor vehicle in which the only item removed was a firearm. And there was, of course, testimony from Ms. Thaxton in regards to the fact that she observed the gun there on the chair with Mr. McElhaney there next to it when he was attempting to get into her home. The points that I wanted to bring up, Judge, is this. Mr. McElhaney has had numerous opportunities throughout his life to seek treatment, to get help. I have no doubt that he has a drug problem, but it falls back on Mr. McElhaney to make that choice. He testified on the stand that his children were taken due to drug usage, but he didn't seek treatment at that point. That his loved ones, his aunt testified that she tried to get him to go to treatment, and he wouldn't go to Synergy at that point in time either. And then while he was on probation for Murray County, where the probation officers who are willing to assist and get someone into treatment, he didn't request treatment then either, and that was in January of 2024, or up till time of these offenses. And so now we're here before the court, and Mr. McElhaney is facing a lengthy prison sentence, and now he has discovered that he wants treatment. And I think at this point in time, Judge, my argument would be whether or not he deserves to have yet another opportunity, yet another chance. And the reason I say that, Judge, is that what he's been convicted of is serious. He may not have stolen anything that day material-wise, but he stole people's peace of mind, and he stole their security within their own home. And you've heard from two separate victims that told you that. You can't get that back after something like that has happened. Ms. Thaxton stated that she ended up having to go to the emergency room due to what happened to her. And at this point in time, Judge, I am asking that Mr. McElhaney take whatever opportunities he has in prison for treatment, and that's how he goes about and receives his treatment. And I'm asking the court to sentence Mr. McElhaney to serve the full 10 years, up to 10 years in prison. Thank you, Your Honor.
Talbot?
Thank you, Your Honor. The defense also filed a notice of mitigating factors and some supporting documents. And we would ask the court to consider the following mitigating factors. That the defendant's criminal conduct neither caused nor threatened any serious bodily injury. From the evidence that was presented today, it's clear that the defendant at no point threatened anyone with any kind of harm, made no verbal threats, and no one was in fact harmed, incurring serious bodily injury. And in fact, the testimony from Mr. Zajac was that when he directed the defendant to leave his property, the defendant did so. Further, we would ask the court to consider that the defendant was motivated by the factor that the defendant was motivated by a desire to provide necessities for his family or for himself. In this case, the defendant did testify that he was seeking water and gasoline for the vehicle that he was using, and that was the purpose of him looking around these properties of the victims. And again, he took nothing. We also ask that the court consider Factor 11, that the defendant, although guilty of the crimes, committed these offenses under such unusual circumstances that it is unlikely that a sustained intent to violate the law motivated the conduct. The defendant testified that he was under the influence, which on its own is not a factor that the court should consider, but it is part of the circumstances in which he, under the influence, found himself more or less stranded due to his vehicle that he was using running out of gas, and that he was then looking, based on his testimony, for something to refuel his vehicle and water on an August night. I would also ask the court to consider that Mr. McElhaney's drug use has cost him a lot and played a role in a lot of the criminal conduct that forms his history. He admits that he does have a drug problem, and he's seeking help for that. I would ask the court to consider the policy purposes of the Tennessee Criminal Sentencing Reform Act of 1989. Among them is that the defendant should be punished by the imposition of a sentence that is justly deserved in relation to the seriousness of the offense. We ask the court to weigh the mitigating factors in light of that. It is also the policy goal of the Tennessee Criminal Sentencing Reform Act, its purpose, that effective rehabilitation be encouraged, where a defendant may, where reasonably feasible, undergo alternative sentencing and correctional programs that elicit the voluntary cooperation of that defendant. The court's encouraged to consider those options and promote their use when possible, when reasonably feasible. In this case, the defendant has been accepted to the recovery court of this judicial district. We heard testimony today that the defendant was accepted and that he is regarded as a good candidate for recovery court. So based on the purpose of the Tennessee Criminal Sentencing Act at 4035 1023C, this would be an alternative sentencing and correctional program that is based on the voluntary cooperation of the defendant. It requires his voluntary cooperation unambiguously, unequivocally, and it would promote his effective rehabilitation. And we believe it's I would show the court that it is reasonably feasible here due to him being accepted and due to the effectiveness of the recovery court program. Central to this is the system, the regime of sanctions that's available in the recovery court process. This is not something that the defendant has ever been subjected to. This will be a new setting for him, new requirements, new conditions, new restrictions. And if he fails to comply with that, there is a wide range of sanctions that can be tailored to the problem to address it, should he fail to do what he's supposed to do in the recovery court program. I submit to the court that that is a serious commitment on the part of the defendant, and that him being subject to such sanctions through the recovery court reflects the seriousness of this offense and what the victims experienced. And so we ask the court to consider that as the proper choice for the defendant. Another thing that the court has to decide is the range of sentence on not the aggravated burglary, but the vehicle burglary and the attempted aggravated burglary. On those, Your Honor, I believe that there is a range of punishment that the court will consider. It may be less significant given that 10 years will be the sentence on the aggravated burglary, which is a C felony. And at range 3, the bottom of the range is 10 years. And that is the agreed upon cap on the aggregate sentence here. It would be 10 years at 100% on that. Nevertheless, Your Honor, because that is a ruling that the court does have to make, we would ask that the court give the defendant the bottom of the range in both of those. One of the advantages of sending the defendant to the recovery court program will be that it will address one of the issues identified in the risk assessment completed as part of the pre-sentence report. The defendant had a high rating of risk or a moderate rating of risk in the category of, I believe it was residential and perhaps relations. I'm not sure exactly what the language was used there. Friends, associates, and residential, 62% risk. That was his highest area of need, deemed moderate in the risk assessment. Recovery court would address that because his living situation will be controlled and who he can associate with is controlled and he'll be closely monitored. That may be something that speaks to, addresses Mr. McElhinney's identified need there. And therefore, it makes it a better candidate, better option for him. So, in summary, Your Honor, there's a state legislative purpose or policy with respect to sentencing for there to be rehabilitation when reasonably feasible. The goal of punishment and deterrence is also met with recovery court because sanctions for the defendant's conduct in that program are available and will be used. Recovery court has identified the defendant as a candidate for the program that they believe can be helped through the program. The consequence of the defendant's failure to abide by that program and complete it is serving his sentence. The sentence report that we heard testimony about corroborates that the defendant has a known drug issue that may be treated. Due to all of this, sentencing the defendant such that he has to attend recovery court and complete that supports more goals of sentencing than simply sending him to prison. So we ask that the court order the defendant to undergo recovery court and complete that. Thank you, Your Honor.
General Wojciechowski, you have anything else? Mr. Talbot has pointed out the provisions of the sentencing law. This court is required to adhere to the sentencing guidelines that our state legislature has promoted and adopted through statute. I can't just do what I want in a case per se. I have to abide by those regulations. And those are the purposes of the chapter that Mr. Talbot referred to are set out in 4035-102. And for that, I will go through some of those that were not mentioned by Mr. Talbot, who is a very able advocate for his client. First is that every defendant should be punished by the imposition of a sentence justly deserved in relation to the seriousness of the offense. Two, this chapter is to assure fair and consistent treatment of all defendants by eliminating unjustified disparity in sentencing and providing a fair sense of predictability of the criminal law and its sanctions. Three, punishment shall be imposed to prevent crime and promote respect for the law by A, providing an effective general deterrent to those likely to violate the criminal laws of this state. B, restraining defendants with a lengthy history of criminal conduct. C, encouraging effective rehabilitation of those defendants where reasonably feasible by promoting the use of alternative sentencing and correctional programs that elicit voluntary cooperation of defendants. And D, encouraging restitution to victims where appropriate. 4, sentencing should exclude all considerations respecting race, gender, creed, religion, national origin, and the social status of the individual. And it goes on to talk about the encouragement of alternatives to incarceration under the appropriate case. This sentencing considerations are set forth in 4035-103. To implement the purposes of this chapter, the following principles apply. 1, sentences involving confinement should be based upon the following considerations. A, confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. B, confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to those likely to commit similar offenses. C, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. 2, the sentence imposed should be no greater than that deserved for the offense committed. 3, inequalities in sentences that are unrelated to the purposes of this chapter should be avoided. 4, the sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. 5, the potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining the sentence alternative or the length of time to be imposed. The length of term of probation may reflect the length of treatment or rehabilitation program in which participation is condition of the sentence. 6, trial judges are encouraged to use alternatives to incarceration that include requirements of reparation, victim compensation, community service, or all of these. He goes on to talk about available community-based alternatives to confinement and the benefits that are imposing such alternatives may provide to the community should be considered when the offense is nonviolent and the defendant is a primary caregiver of a defendant child. So implementing those, both the purposes of the chapter and the sentencing consideration, the court finds that the sentence involved in this case would be taking into consideration that the defendant has a long history of criminal conduct. It's been pointed out that he has 20-plus years of criminal conduct, either 9 or 7, depending on which version you accept, felony convictions, multiple misdemeanor convictions. He has convictions for other convictions, prior convictions for theft, and a conviction for burglary in his past. Goes on, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant, and the proof has been that the defendant was on probation out of Murray County at the time that he committed these offenses. So those are some court findings regarding the considerations and those factors that are set out. Then moving to determining the range, it was stipulated that he would be a range 3 offender or a persistent offender, as the law provides, which means that in the consideration of the Class C felony, his sentence, if it had been open to the court, would be 10 years up to 15 years. That would be the range for the Class C aggravated burglary. By agreement between the state and the defendant, he received the consideration of limiting or capping the sentence to 10 years so that the court cannot consider a sentence in excess of the 10 years that was ordered. The sentence range for the vehicular burglary, which is a Class E felony for a persistent offender, is 4 to 6 years. And for the attempted aggravated burglary, the sentence range is 8 to 12 years. And again, the agreement was to cap the sentence range the sentence at 10 years. Court then moves to determine the sentence as to the enhancement factors that the state has submitted, and those enhancement factors are as follows. The defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range. Court finds that that factor does apply, that the proof, as I previously stated, is that he has a 20-year plus history of criminal conduct. He has multiple convictions, both felonies and misdemeanors, and has previously been on probation during that time. Number 3, the victim of the offense was particularly vulnerable because of age or physical or mental disability. I didn't get the impression Ms. Thaxton was very particularly so elderly that she was not disabled, but she is like me. She's not a young person, so I do find that that is a factor to it. And she lives alone, and being isolated in her home by herself, I think that is a factor that would be applicable in this case. Number 13 of the enhancement factors, that the time the felony was committed, one of the following classifications that is applicable to the defendant, he was released on probation. I find that to be, the proof has established he was on probation out of another county when he committed these offenses. And Number 29, the offense involved the theft of a firearm from a motor vehicle. And the court does find that although he did not plead to the actual theft, that the proof here has clearly established that there was a theft of the firearm from the motor vehicle. That was part of the reason that the court asked the question of Mr. McElhaney that how did the weapon get from the vehicle into the front porch of Ms. Thaxton, was to determine, number one, his acceptance of responsibility, and number two, his credibility as a witness. The court finds all of those factors to be applicable. So there are four factors that, enhancement factors that the court finds. The mitigating factors that the defendant has submitted are one, that the defendant's criminal conduct neither caused nor threatened serious bodily injury. I'm happy that there was no serious bodily injury. Mr. McElhaney might want to consider the fact that in my growing up, if somebody had shown up on my father's doorstep in the middle of the night banging on the door, they might not be alive the next day to have to deal with anything. So luckily, there was no serious bodily injury or harm. The same thing with the other cases that were involved in this situation. I don't know that Mr. Zajac would have done anything like that, but I think there is, it is applicable to me that he's lucky that there was not a more serious result of this. But Ms. Thaxton deserves to live in her home without fear. Mr. Zajac and his family, they deserve to live in their home and have a sense of security, and they've been robbed of that by the actions of the defendant in this case. And while it might not rise to the level of serious bodily injury, it is a consideration that this court finds to be appropriate in determining the sentence in this case. Number two, that the defense argues is number 7, rather, that the defendant was motivated by a desire to provide necessities for the defendant's family or the defendant's self. I have listened to Mr. McElhaney and listened to the proof that the state put on from these witnesses about his behavior around their home is inconsistent with his version that he was simply looking for gasoline, or that he was, just wanting to cool off with a hose or whatever. He may have been on drugs, but my opinion is that you don't go looking for gasoline if you're committing a burglary of a vehicle. That's not the purpose of it. And so for that reason, this court does not find that there was any indications substantiating the fact that he was acting on behalf of himself and seeking the necessities of gasoline. I think that factor is also more applicable in a situation where a person commits a theft because their family is hungry or starving or something, and they've been motivated to provide necessities for themselves or their families. That's the court's interpretation of the purpose of that. I do not find that to be applicable in this case. Number 11, the defendant argues that the defendant, although guilty of the crime, committed the offense under such unusual circumstances. It is unlikely that a sustained intent to violate the law motivated the criminal conduct. This court is of the opinion that this defendant's prior criminal record of burglary and theft do not make this an unusual circumstance that he's unlikely to have committed another crime. I think it is consistent with his prior pattern of behavior and criminal conduct. In addition to that, this is not one isolated knocking on a door to see if anyone's home or whatever he was doing, but rather is a pattern of the neighborhood of him going from house to house and trying to see if there was anyone home that he could, for whatever purpose. So it's not a situation where I think it's unlikely it was sustained intent to violate the law that motivated the criminal conduct. So I don't find that those things are applicable as well. That factor is applicable as well. And number 13, the basically catch-all, the court is well aware that, and I agree, I think Mr. McElhaney has a drug problem. And as a result of that, I think he is clearly has been in for many years suffering from a drug addiction, and for many years has been in need of treatment. The problem with that is that he has been given opportunity after opportunity, including the Hope Center, and has not taken advantage of any of those opportunities. It seems to me that despite having been available treatment options for him in the past, it's like he said himself, he just, wasn't ready for it. And I have great respect for the Dixon County, or the 23rd Judicial Drug Court. I think they do a great work, and I think Mr. Barnhill is a very compassionate individual. His job is to try to see the good in people and to try to help them redeem themselves. My job is to not only try to judge people as far as whether or not they are credible, but also whether or not they are willing to and undergo a treatment that would help them, but also to balance that with the respect that I have to have for the protection of the society as a whole. So while I have great belief in the drug court program, the fact that this gentleman has been on probation over and over and over again is an indication to me that recalls the old saying that the definition of insanity is repeating the same thing over and over and over again and expecting a different result. I hope that Mr. McElhaney is serious about wanting to have treatment for his addiction, but this court is of the opinion that rendering him into the drug court program is not in the best interest of society and does not comply with what I believe the requirement of the law is. So therefore, as to count one of the aggravated burglary charge in docket number 134, he is sentenced to serve the 10 years in the Tennessee Department of Corrections. Count one of the 135, he is sentenced to 6 years for vehicular burglary and is ordered to serve that sentence, obviously contemporaneously with the 10-year sentence that I've previously indicated. Count 4, he is on the attempted burglary, he is sentenced to 10 years on the attempted burglary, which is a Class D felony, and court has ordered that be run. I mean, the agreement is that it's capped at 10 years for an aggregate sentence, so he is ordered to serve all of those as concurrently, and also concurrently with his Murray County. He'll get pre-sentence jail credits as set forth on the plea agreement until today, and that is the judgment of the court.
Your Honor, for his pre-sentence jail credits, that would be amended to reflect his time through today's hearing.
Yes,
I would think,
he'll
Your
get
Honor.
pre-sentence jail credits through today.
Yes, sir. Thank you.
All right, that concludes the cases that we have set for today.